My name is Pat Treacy and I'm a partner with the competition team at the law firm Bristows in London. And this session is a discussion of how you can maximise privilege in competition law matters. I'm going to deal with the issue in essentially 5 parts. First of all, I'm going to talk a little bit about what privilege is and why it matters. I'm going to talk about when privilege might be relevant for competition lawyers. Then I'm going to look at the scope of the rules relating to legal privilege in the European Union before talking a little bit about how privilege should be dealt with in the context of investigations by the European Commission. And finally, just going to give a few practical tips as to how you can protect privilege or maximise the protection of privilege in the way in which you carry out your business. So the first and fundamental question is really, well, what is privilege? And the short answer is that privilege relates to communications between a lawyer and his or her client. And the reason why privilege matters, the reason why it's accepted that privilege is important, is because there's regarded as being a fundamental right for individuals and companies to have access to legal advice and to be able to exercise that right of access without undue constraint. And it is recognised by the authorities that if advice given by a lawyer to his or her client is capable of being used as evidence against that client in some form of court procedure or regulatory investigation, that the likelihood is that clients will be less willing to take advice from lawyers, or to the extent that they do take advice from lawyers, will be less willing to do so in an effective way, in other words, through written advice. And that is seen as being fundamentally not helpful to the right of access to justice. So that's privilege and what it is. I think the next question we want to talk about is, when might privilege be relevant in competition law matters? I think there are 2 circumstances in which privilege is likely to be relevant in competition law matters. The first is if a company is subject to an investigation or a request for information from a competition authority as part of a regulatory investigation. And that's the most common context for many lawyers. The other time when privilege may be relevant to competition lawyers or in relation to competition matters is if there's an action in court, in the court of a member state or a third country jurisdiction, in which the possibility of documentary disclosure or discovery arises. And in those contexts, it may well be absolutely fundamental to the client's rights of defence to be able to withhold from disclosure or discovery legally privileged documents. So those are the 2 principal contexts where privilege may be of interest. I think it is fair to say that although the doctrine of legal privilege is well recognised in most jurisdictions, the way in which it is applied in practice is really quite different in small but very important details. So when it comes to talking about privilege today, I thought that the best and most helpful thing was to look at the approach and practice and the rights under European Commission investigations. Because I think if you find yourself in a situation where legal privilege becomes important in the context of a national investigation or before a court, it's really important to seek legal advice as soon as possible about the exact scope of privilege in that particular jurisdiction and what you may be able to withhold or what you may be obliged to give up. So, stopping there, what rules will the European Community apply, and when might those rules be relevant? There are 2 things you need to think about in the context of a European Commission investigation. The first is the possibility that you may be asked to provide information in a written form, so you may receive a request for information or a documentary request. The rules on privilege will apply, and in responding to such requests you are entitled to withhold any documents that are covered by the legal privilege exception. The other and much more difficult area where privilege may apply is in the context of so-called dawn raids. Now, a dawn raid is when the European Commission exercises its powers, and it does have these powers, to visit your company's premises, or in some instances other premises, and to carry out an on-the-spot investigation, looking for evidence of anti-competitive behaviour. In the context of a dawn raid, the Commission has the right to take copies of documents or to take copies of legal or of information on computer systems, and in some instances to go into other premises such as company cars or company boats, or potentially even to ask for access in some circumstances to the premises of individuals in order to look at documents and to take copies of them. Now, in the context of an on-the-spot investigation or a dawn raid, you will be under incredible time pressure and significant pressure generally, and it's very important in that situation to be alive to the need to watch out for legally privileged documents. And it's important for a number of practical reasons. The first of which is there's a doctrine which has been developed by the European Court that once someone within the Commission or elsewhere has actually looked at a document and has become aware of its conduct, of its contents, this may give them such knowledge that they will then be able to rely on it. The privilege will have disappeared. They can't be forced to give it back. So I think the most scary, but also the most important area to be aware of legal professional privilege is in the context of dawn raids. Having looked at the times when privilege may be important, and having spoken a little bit about the broad concept of legal professional privilege, I think it is important to pause there and to look at some of the really important concepts that the courts have developed to identify precisely what legal privilege is in the context of European Commission competition investigations, and what the limits of that privilege are, because both are extremely important. So turning to the scope of legal professional privilege in the context of EU Commission investigations, let's start with some of the things that are not covered by legal professional privilege, and some of these may be quite surprising. First of all, legal professional privilege does not apply to communications between a client and his in-house lawyer. So if a company has an internal legal advisor who advises on matters of competition law, the advice given by that individual to his corporate client is not covered by the scope of legal professional privilege. And this has been a constant ever since the very first case in which the acceptability of legal professional privilege was first held by the European Court of Justice, a case called AM&S back in the early 1980s. The reasons for this distinction are somewhat difficult to understand, but in broad terms, the European Court of Justice has held that because an in-house lawyer is employed by his company, he doesn't have the requisite degree of independence to enable him to advise properly. This is a matter which has been very seriously criticised by lawyers all around the world, both internal and external, but in a relatively recent case, in the AXO case, the court upheld this principle. So communications will be protected by legal professional privilege only if they are exchanged between a client and his external independent lawyer. The second limitation on the type of lawyer who can give advice which is protected by privilege under European rules is that the lawyer must be qualified to practice before the bar of a member state of the European Economic Area. This means that if the lawyer in question is qualified, for example, in the United States, or in Australia, or in Russia, that the advice that he gives on matters of competition law will not be covered by legal professional privilege in the context of investigations which are carried out by the European Commission. Again, a somewhat strange distinction, but it's very important to be aware of it. Thirdly, the advice privilege relates only to communications between a lawyer and his client. It does not relate to communications between a lawyer and the lawyers acting for third parties. That is at least the view of the European Commission. This has not yet been tested before the European courts, but it was a matter which came up in the context of certain investigations in the pharmaceutical sector, and it was held that notwithstanding the fact that communications between lawyers would be privileged under UK law, they were not privileged in the context of a Commission investigation. So those are three pretty important and fundamental limitations that need to be borne in mind. Looking at the positive side, it is clear that although privilege relates to legal advice, it can also be extended in some fairly limited ways. And in the AXO case, to which I've already referred, the court held that preparatory documents which were put together by a client for the sole purpose of seeking external legal advice could be privileged, even if they were never actually sent to the lawyer, but were gathered together and created in order to seek advice. So that is quite a useful thing. I think the second minor extension is that if a document or a note is created by the client simply for the purpose of reporting legal advice that he has received, so for example in the context of a video conference or a meeting, then those notes will themselves be privileged as long as they go no further than simply reporting the content of the advice that was given. Looking at the scope of the advice that may be privileged, the rule is that legal professional privilege relates to documents that have a connection with the subject matter of the investigation and which are prepared for exercising the client's rights of defence. That's what the case law says. Now, what does that mean in practice? Well, in practice it means that as long as the documents are relevant to what is being investigated, then they will be protected. It doesn't matter that the documents may have come into existence before the Commission investigation began, as long as they are related to the subject matter of the investigation and therefore are relevant to the client's rights of defence. And if you think about that in the context of a competition law investigation, you can think that the Commission may start to investigate a particular practice many years after the practice was first brought into operation. Legal advice in relation to the application of competition law that was given at the time when the practice was first thought of will continue to be privileged. Just pausing there is a slight issue that you need to be aware of. It is the view of the European Commission that the only advice that is privileged in the context of a Commission investigation is advice that relates to the application of the competition rules. Why is this so? The Commission says, well, this is because that is the subject matter of the investigation. This issue has never yet been ruled on by the courts, and it is potentially capable of having quite significant implications in certain situations. Take, for example, a situation where the Commission may say that the exercise of an intellectual property right, let's say a patent, is contrary to the rules on competition because the patent is invalid or because the company is dominant or for other reasons. The Commission's view is that advice given by independent lawyers on the validity of the patent or whether or not it's infringed will not be privileged in the context of that competition investigation because it does not relate specifically to the application of competition law. As I say, that is not definitively settled, but my understanding is that that is the view that the Commission has taken in certain circumstances. If this is a subject that is of particular interest to you, and if you want to have a more in-depth summary of the rules that apply, it is worth looking at the European Commission's best practice guidelines, which do give a reasonably thorough summary of the rules relating to legal professional privilege in competition investigations. But do bear in mind when reviewing those guidelines that there are certain things in the Commission's practice or general approach which have not yet been absolutely ruled on by the European courts, and there may be some scope for debate about some of the positions the Commission may seek to take in the context of an actual investigation. Having talked a little bit about the scope of legal professional privilege, and you'll see that it's not such a straightforward matter, I thought it would be useful now to talk for a few minutes about how in practice you deal with these issues in the context of the very pressurised situation that can arise during a Commission dawn raid or on-the-spot investigation. And that's what I'll turn to now. So when you're in the cauldron of a Commission investigation, how do you do your best to ensure that Commission officials do not take copies of or even read the contents of documents that are regarded as being legally professionally privileged? Some of these are just practical tips, but some of them have their roots in case law. And the case that is probably most helpful in understanding the procedure to follow during a dawn raid and the underlying reasons for that procedure is the relatively recent case of AXO that I referred to earlier. In practical terms, in any Commission investigation, it is extremely important that any Commission officials who may be on the premises are accompanied and assisted by someone who represents the company. And if possible, that person should be legally qualified and should have a good understanding of the rules on Commission investigations generally and professional privilege in particular. Because as the investigation goes on, there will inevitably be questions that come up about the nature of particular documents. And because companies can be significantly harmed if the Commission officials actually read legally privileged documents in the first place, it is regarded as being very important that Commission officials are not even allowed to have a cursory glance, is the word that's used, or a quick look at the contents of legally privileged documents. So how in practice can this be prevented? Well, the procedure that the courts have suggested people should adopt is that if there is a document identified which the Commission considers to be relevant to the investigation, but where there's a question that it may be legally privileged, what should happen is that the undertaking or the company's advisors, should explain to the Commission the reasons why the document is considered to be legally privileged. And they should not claim legal privilege unless they have good reasons for doing so. So there's a genuine dispute about whether or not the document is legally privileged. In those circumstances, the undertaking is entitled to refuse the Commission the right to look at the document, but they should give some explanation for their refusal. And the way in which this can be done is that the company can explain who the document was written by and who the document was written to. It may be possible to show the header. If the document is from a law firm, then you could perhaps show the law firm header. In these days of emails, it may be necessary to show the signature block at the bottom of the email. If the email is marked privileged and confidential, and you can establish that it's to or from an external lawyer, that may also be sufficient. So there's usually a reasonable amount of debate about whether or not a particular document might fall within the context of legal professional privilege. Now, of course, from what I've said already, you'll realise that just because a document is to or from a lawyer doesn't automatically mean that legal professional privilege applies. It may be that it is outside of the scope of privilege as the Commission sees it. If there's a real dispute about whether or not a particular document is in fact privileged, then there is a particular procedure which should be followed both by the Commission and the party. It's very often difficult to actually deal with these issues during the day when the investigation is still going on. So practically speaking, it is usual for the leaders of the defence team and the leader of the Commission investigation team to meet at the end of the day and to try and resolve any problems that haven't been capable of resolution during the day. In respect of documents where there's some dispute, either about their relevance or their privileged nature, the practice that is adopted is that a copy of the document is placed inside a brown envelope at the time when the dispute arises. At the end of the day, there will be a further discussion between the Commission and those defending the company as to whether or not the Commission is persuaded that actually the document is either irrelevant or is indeed covered by legal professional privilege. If the Commission accepts that view and is persuaded of it, then the matter goes no further. If, however, the Commission does not accept that view, then the company is still wholly entitled to refuse the Commission's sight of the document. The procedure that needs to be adopted is that the Commission should take away a copy of the document in a sealed envelope. They must not look at it, they are not entitled to look at it, even to have a quick glance. If the Commission, after it's gone back and considered the general circumstances, still believes that those documents are not covered by legal professional privilege and are covered by the scope of its investigation, the Commission must take a formal decision requiring the company to hand over the documents in question and not to claim legal professional privilege. The company then has the right to appeal that decision to the European Court, the General Court, which is the initial appellate body within the European Union. And the decision as to whether or not the document is in fact legally privileged will be taken by the General Court. It will not be taken by the Commission. If there are disputes about the sealed envelope procedure and how it ought to be operated, there is an individual within the Commission called the hearing officer, and it is his job to oversee disputes of this nature. I think the most important practical point in all of this is that if you wish to claim legal professional privilege over a document, the first most important thing is not to allow the Commission to read the document. That is very important. The second thing is that you should not claim legal professional privilege over documents that clearly do not fall within the scope, because there is the potential, if you refuse to hand over a document for which there are no legitimate grounds for arguing that it may be covered by legal professional privilege, you may be fined by the Commission for obstructing its investigation. However, if there are genuine grounds for dispute, then put the document in a brown envelope, have a discussion at the end of the day. If the matter cannot be resolved, then those discussions can continue after the dawn raid. You can make more submissions to the Commission, and if ultimately the Commission continues to disagree, then the matter will be handed to the European courts. So it may sound like a slightly cumbersome procedure, but it is a procedure that the courts have imposed both on companies and on the Commission. And I think, it's worth, I don't like necessarily reading from documents, but I think it's worth just telling you what the European Court about this has said about this procedure. The protection of legal professional privilege seeks to safeguard the public interest in the proper administration of justice, ensuring that a client is free to consult his lawyer without fear that any confidences which he imparts may subsequently be disclosed. Secondly, its purpose is to avoid the harm which may be caused to an undertaking's rights of defence as a result of the Commission reading the contents of a confidential document and improperly adding it to the investigation file. Therefore, even if that document is not used as evidence in a decision imposing a penalty under the competition rules, the undertaking may suffer harm which cannot be made good or can only be made good with great difficulty. Information covered by the legal professional privilege might be used by the Commission indirectly or directly in order to obtain new information or evidence. Moreover, the harm which the undertaking concerned would suffer as a result of disclosure to third parties of information covered by legal professional privilege could not be made good if that information were used in a statement of objections. The mere fact that the Commission cannot use privileged documents as evidence in a decision imposing a penalty is not sufficient to make good or eliminate the harm which result from the Commission's reading of the documents. So you can see that there is very strong judicial support for using a procedure which does not allow the Commission to have sight of the documents. And that's paragraph 87 of the judgment in the access. So having talked a little bit about how privilege can be dealt with in the context of an investigation, you'll see that sometimes the pressure is quite significant, and sometimes identifying privileged documents may be difficult. So the final thing I want to touch on briefly was how you can best give yourself the chance of maximising the protection of genuinely privileged documents in the context of commission investigations. And some of these may seem very obvious, but it is quite extraordinary how often they can be overlooked, particularly if the advice doesn't seem at the time particularly controversial. I think the first tip is where documents may be legally privileged, it really does make sense to label them privileged and confidential, because at least that's a little bit of a tip-off to you that this is a document that you really need to look at. Good practice suggests that if you think that the European Commission may be particularly interested in the document, and of course, if it's true, the document should be labelled privileged and confidential, legal advice relating to competition law, prepared by external EU counsel, or something along those lines. That may seem like a bit of a mouthful, and it probably is, the best practice. But at least labelling a document privileged and confidential gives those who are in the maelstrom of a competition investigation a moment to think, actually, this is a document that I need to look at and consider before I allow the Commission officials to do so. It may be, after you've undertaken that review, that in fact the document in question, for one reason or another, is not protected from disclosure under the European rules. But at least it's a good prompt to stop and think. It is best practice, if at all possible, to try and keep privileged documents, and particularly those that give formal legal advice, separately, in a separate folder which is marked privileged and confidential legal advice. And this would apply both to physical documents and to documents on an IT system. Now, of course, there will always be documents which potentially could benefit from the legal advice exception that may not be formal legal advice. But if at all possible, those documents that genuinely do contain legal advice on competition law matters should be kept separately marked in a separate file. The risk of a document slipping through the net is higher the more widely a document is disseminated. So it is good practice generally to make sure that legal advice is not sent outside the scope of those who need to receive that advice. If you can keep circulation relatively limited, it minimises the risks that something may inadvertently be given to the Commission or to an investigating authority which really should not have been. There is another reason for that particular comment, and that is that in the laws of some member states, if a document is too widely disseminated, then it loses the character of confidentiality, which is said to characterise legal privilege. So it is good practice not to circulate legal advice beyond those who really need to receive it. It is often sensible to ensure that if a document is being collected for purposes of analysing competition law concerns, or it gives rise to some particular competition law risks, that it should be copied to an in-house and an external lawyer, and they should be asked to comment on the competition issues to which it gives rise. It is very important, practically speaking, to make sure that anyone who might be involved in a dawn raid have at least some training or some guidance notes to refer to as to what they should do in the event that they find themselves faced with a Commission investigator who is asking them simply to hand over all their documents. In extremis, one thing that can be done if there is a real and genuine dispute before you go into the sealed envelope procedure as to whether or not a document is privileged, or if the issue arises more likely in national litigation, one of the things that you might consider is instructing a respected external lawyer or retired judge to consider the document and to give advice or an opinion as to whether or not it is in fact privileged under the particular rules that apply. That's more likely to be the case in litigation than it is in the context of commission investigations, but it's still something that's worth considering where there is a genuine dispute. As this presentation will probably have made you aware, there's a good deal more to the concept of legal professional privilege than you might immediately think. So please, if you do have a question on these issues, do not hesitate to consult a lawyer who's expert in them, because there are quite a number of little tricks and pitfalls that otherwise can trip you up. Thank you very much.